question, I had not been briefed as to whether or not the Associate Minister had any information regarding the evidence of fraud.
Thank you. I call Chris Hockenbowl.
Thank you, Mr. Speaker. I'd like to take a relatively short call on this, not that it is a subject which doesn't excite interest, but it's just that we've already heard from speakers who are well versed in the justice system, and I think they've covered an awful lot of good points. And I enjoyed listening to Charles Chauvel speaking about his earlier occupation. It's one that does stir a lot of interest. The bill that has been introduced by Dr. Kennedy Graham seeks to deal with what is assuredly, Mr. Speaker, a most important issue, ensuring we have confidence in the judges who hear the public cases, and that they're free from any conflict of interest that could lead consciously or unconsciously to incorrect decisions being made. The Law Commission acknowledged the serious nature of the issue raised by Dr. Graham's bill, and I think it's a credit to him that it attracted the attention of the Law Commission. That being said, it still leaves a number of questions. Is there a legitimate issue? Whether a practice or perception that needs to be addressed? And if so, is this bill the right way to do that? Do we have a problem in New Zealand which requires pecuniary interest registers for judges with the issues that such a register requires? The Law Commission gives this matter careful treatment in its issues paper. It's important to note, Mr. Speaker, there have in fact been very few cases where pecuniary interests have been the basis for a challenge to a judge sitting in a case in New Zealand. The Commission's paper outlines the positions of other common law countries. New Zealand is substantially the same as England and Wales. Australia and Canada have no plans to introduce registers for judges' pecuniary interests. The Law Commission concludes that the law relating to when judges must recuse themselves from trials is both well settled and consistent with comparable jurisdictions. Mr. Speaker, this bill would not clarify the issues surrounding the process by which a judge is removed from presiding on a case. The bill is directed towards a substantive identification of conflicts, but not the process surrounding the conflicts in general. The Commission's view, and my view as well, is that there's no need for a legislative intervention. Instead, any deficiencies in the way judges apply the process for recusal decisions, I think, are better made by the judiciary itself through the rules of the court or similar procedural measures. I support, however, the proposal to forward the bill to a select committee. Thank you, Mr. Chairman. Mr. Speaker.
I call Gareth Hughes.
Kia ora, Mr. Speaker. Ngā mihi nui kia koutou kia ora.